Well, good evening, everybody, and welcome to this very special evening. It's special for a number of reasons. First, it is to celebrate the wonderful response to Bickle's appeal, which has enabled us to establish these premises as a fitting home for the Institute and provided the funding we needed to ensure that we shall continue in the years ahead to perform our preeminent role of applied research in the field of international and comparative law. Products of this research are playing an increasingly important role in buttressing the rule of law around the world. Secondly, this evening is special because it brings together those who care about Bickle and whose generosity and industry have contributed to the success of the appeal and the strength of the Institute. Members of the President's Circle and other generous donors to the appeal, members of the Institute who have helped and supported it over very many years. A particular welcome to those joining us remotely, who include, I believe, Sir David Edward and Sean Wilkin in Scotland, Charles Brower in the United States, and Vaughan Lowe, Sam Wordsworth, Craig Orr, and Murray Rosen. And I've been asked, please, if you are watching this with your camera switched on, so that the audience are watching you, could you kindly turn it off when we have the main speech? Thirdly, this evening is special because we have come to listen to a lecture from a rather special person. The office of Chief Justice of England and Wales dates back to the 13th century. The title, Lord Chief Justice, was not officially created until 1875 and reflected the fact that the office had always been held by a man. And so it continued to be until the 1st of October 2023, when it was conferred on Lady Carr, who directed that her title should be the Lady Chief Justice of England and Wales. Lady Carr was called to the bar by the Inner Temple in 1987. She did a pupillage in Brickcourt Chambers, which I had just left for the bench, and 2 Crown Office Row, now 4 New Square, which chambers she then joined and later headed. She built up a thriving commercial law practice, specializing in professional liability, insurance, and fraud. She qualified for both as an arbitrator and a mediator and took silk in 2003. In 2006, she was made a governing bencher of the Inner Temple, where she chaired the Education and Training Committee. In 2007, she became chair of the Professional Negligence Bar Association and a year later, chair of the Bar Standards Board. In 2009, Lady Carr was made a recorder and 4 years later appointed to the Queen's Bench Division of the High Court. She sat in the Commercial Court, only the second woman to do so, the first happily being a member of our audience this evening. And she was the first woman to be appointed to sit in the Technology and Construction Court. She was a presiding judge on the Midland Circuit from 2016 until 2020, when she was promoted to the Court of Appeal. I am in a position to appreciate the demands that are now being made on Lady Carr as Lady Chief Justice. And it is enormously generous of her to make this such a special occasion by coming to talk to us. There's one other reason why this is a special occasion that applies only to me. Sue Carr's mother is married to one of my closest Cambridge friends, and we have known each other since she was a child. And so it is with particular personal pleasure that I introduce Lady Carr to speak on mediation after the Singapore Convention.
Thank you. My lords, ladies and gentlemen, thank you for the warm welcome. I thought Lord Phillips was going to say that he had known me since I was this high. What a great honour to have been asked to give this year's President's Circles lecture at the start of 2025. 25 years since the turn of the millennium. Over the course of the last quarter of a century, national and international dispute resolution has evolved significantly. From a national perspective, as we approach 2000, I think we all imagined that the Wolf reforms would be the most significant change that we were likely to see over the next couple of decades. Well, how wrong we were, as the past 10 years of digitization have demonstrated. Digitization being introduced first relatively cautiously and then somewhat faster, not least given the imperatives brought about by the COVID-19 pandemic. From an international perspective, we have seen major developments in international commercial litigation, not least through the development and promotion of multiple international commercial courts across the world, notably in Singapore, Dubai, and Qatar. But today, mediation is my particular focus. But it's not just my focus, it's a central focus for anyone engaged in dispute resolution, as CEDA's 10th annual mediation audit makes clear. Since 1990, when mediation began in earnest in England and Wales, disputes totaling a value of £195 billion have been mediated, with at least £20 billion of disputes now being mediated annually. The savings to business from this are noted as being worth around £5.9 billion, not to be sniffed at. And that benefit, as Lord Phillips himself put it when chief in 2008, stems not just from saving parties to a dispute the cost and the trauma of litigation, but also through enabling them to preserve or restore good relationships with the other party to the dispute. Importantly, it enables them to expend their time, their efforts, and their resources on their commercial activities and not litigation. This is, of course, a point well recognised by Bickel. Bickel's emphasis on the need to encourage mediation, or as it called it, conciliation, to help promote the continuing viability of contracts during the pandemic, highlighted the really important role that mediation had to play then. But what is good for business in times of crisis is just as beneficial in the ordinary course of events. There has, as is well known, been something of a perceived tension between mediation, or perhaps its promotion, and litigation, particularly acute during the first 2 decades of the century, when the promotion of mediation and alternative dispute more generally really got underway. Professor Hazel Genn, for example, wrote cogently of concerns about the over-promotion of ADR and the risk that this posed for our commitment to an effective civil justice system. Any sense of friction between litigation and ADR now has somewhat cooled. Lord Neuberger, when Master of the Rolls, rightly noted the need to ensure that ADR and hence its promotion must be viewed as playing a supplementary and complementary role to that of litigation. Similarly, as Chief Justice Menon noted in 2015, when discussing the development of mediation in Singapore, it was necessary to move away from the view that ADR was an alternative to traditional court systems and processes. On the contrary, it was necessary to see it as an essential element in a range of tools that are able to be found in a complex and rich toolkit that is available to resolve disputes. Developments over the last 10 years, I think, have seen that shift in mindset. We have, for example, seen the integration of mediation into our civil procedure here through the HMCTS modernisation programme, and most recently, through the Court of Appeal's decision in Churchill and Merthyr Tydfil, where the Master of the Rolls and I confirmed that the court has the power to mandate the use of ADR. We've also seen it with the promotion of early neutral evaluation. And we've seen that shift in family disputes, financial dispute resolution hearings. Internationally, the increasing promotion of international commercial mediation, particularly through the recent introduction of the Singapore Convention on Mediation, but also the refurbished Model Law on International Commercial Conciliation of 2002, and now the Juncker Model Law on International Commercial Mediation. In today's lecture, I want to explore how mediation may evolve in the light of the Singapore Convention. In particular, I want to consider the idea that such development is likely to play an important role in promoting the rule of law, both domestically and internationally, as is happening with the promotion and development of international commercial courts. Finally, I want to consider what lessons we here can learn from the Convention and the approach of other jurisdictions to mediation. Suitable topics, I hope, for a Bickel audience. The background to the Singapore Convention is the recent boom in international arbitration. It's well known that the primary means through which international commercial disputes are resolved is through arbitration. Whilst that is a long-established position, it is perhaps not as rooted in history as one might think. Prior to the Second World War, the primary means by which such disputes were resolved was via mediation, or as it was also called then, conciliation. It has also been said that the birth of international commercial arbitration post-war had a focus on arbitrators actively seeking to resolve disputes not via arbitral awards, but through mediation. As Pierre Lalive once put it, one of the major purposes of arbitration is to encourage conciliation. Leading arbitrator as he was, he is noted as hardly ever having actually determined an arbitration through an arbitral award. His great skill, and that of many of the early generations of international arbitrators, was in fact to bring the parties to a consensual resolution. In one sense, there was nothing new about the approach taken to arbitration in its early years. This was, you could say, the Platonic ideal in action. In considering the best type of judge, in the dialogue between Clinias and an Athenian in the Laws, Plato singled out the one who could arbitrate between the parties. And by arbitration, he meant conciliation rather than adjudication. As the Athenian put it, with our eye to excellence, there is a third type of judge, the one who would be able to take this single family, which is at odds with itself, and not destroy of them, but reconcile them for the future, and given them laws to keep them on good terms with one another. Excellent an approach it may have been, it was overtaken from the 1970s by an equally attractive one, which saw the transformation of international commercial a change in the nature of international commercial disputes, the arrival of arbitrators more familiar with US and English litigation, for example. One key factor was undoubtedly the ease with which arbitral awards could be enforced across borders, not least as a result of the growth of international treaties that facilitated cross-border enforcement. In the absence of comparable mechanisms rendering mediated settlements straightforwardly enforceable across borders, the relative advantage of an award over a settlement is clear to see. Or, as Professor Strong put it, the blame for the decline of mediated settlements and the comparable increase in arbitral awards can be laid at the door of the New York Convention, which played the most significant role in rendering arbitral awards easily recognizable and enforceable across borders. But success all too often brings its own problems. That, I think, has been particularly true of international arbitration. Its growth has seen it mirror the problems that persistently trouble those using the courts. As the 2021 Queen Mary International Arbitration Survey noted, time and cost are perennially acknowledged as the biggest concerns for arbitration users. And in tandem with such concerns, there was understandably a growth in interest in alternatives to arbitration, just as similar concerns, where the civil courts were concerned, has led to a growth in interest and use of alternatives to litigation. From the 1990s, where international commercial disputes were concerned, this led to greater interest in international mediation, offering from international arbitral centres, the ICC in Paris, the LCIA in London, as well as primarily national dispute resolution providers, CEDA or JAMS in the United States. Such growth, however, continued to run up against the same problem. It led to the same problem as led to the shift towards actually making arbitral awards in arbitration, the problem of cross-border enforcement. And so given this, it was, you may agree, perhaps unsurprising that the United States would, as they did in 2014, propose the creation of a new international treaty, one that would facilitate the renaissance of mediation as an effective means to resolve international commercial disputes. That proposal, after significant discussion and detailed empirical study, in stark contrast to some attempts at the reform of civil justice systems, resulted in the development of what in 2019 became the Singapore Convention, the United Nations Convention on International Settlement Agreements resulting from mediation. It's been in force since September 2020. It has currently been signed by 58 countries, including the UK. Of those countries, 14, including Singapore, unsurprisingly, Japan, Nigeria, Qatar, and Saudi Arabia have ratified it. The Convention's purpose is straightforward. Through promoting greater use of mediation, it's intended to increase international trade, to maintain commercial relationships through the promotion of amicable settlement, whilst reducing the cost of dispute resolution to states. Fundamentally, the Convention provides that where an international commercial dispute has been resolved by the parties by mediation, and that agreement is set out in writing, it can be enforced by a state that is party to the Convention. It is, of course, early days for the Convention. It might be thought that with only 14 countries ratifying it, that is less than an auspicious start. But we should take heart. The New York Convention started out with just 10, so perhaps not so inauspicious. Now, whilst I could spend time on the correct interpretation of the Convention's articles, I would rather turn to consider what its wider benefits might be. And my starting point is the potential role that the Convention has in promoting the rule of law. It is trite that the importance of the rule of law cannot be underestimated. It is the bedrock of democratic governance. It is the means by which just law is given effect. It forms the basis on which individuals and businesses thrive within the framework of rights and obligations imposed by legislation and here, the common law. A point most recently reiterated by the current Attorney General, who noted that not only had the case been made for this point by my predecessor, my immediate predecessor, Lord Burnett, and also Lord Hodge, but also by the last 3 years' joint winners of the Nobel Prize for Economics. Over the last 10 years, we have seen a number of states promote the rule of law through the development of international commercial courts. The promotion of international mediation on one level might be thought to undermine the role of international commercial courts and thereby also the rule of law. International commercial courts, like domestic courts, need a healthy diet of disputes. Promoting a further method to compete with litigation, which along with international arbitration may deprive commercial courts of the means to give the judgments necessary to deliver their objectives, might be viewed as self-defeating. To take that approach, however, would be to fall back into old and bad habits, to view litigation, arbitration, mediation, and other forms of consensual dispute resolution as standing in opposition to each other, as competitors, with the success of one harming or hindering the success and efficacy of the others. But the far better view is that the rise of mediation does not mean the fall of litigation. Quite the contrary. Mediation can only exist so long as litigation, leading to judicial decision-making, flourishes. Past judgments form the basis on which individuals are advised whether they have a claim, whether they should settle their claims, and hence the basis on which they should properly settle. In other words, both the decision to pursue a claim and whether to settle via negotiation or the use of ADR depends upon there being an effective civil justice system that individuals can access. And the promotion of international mediation, specifically following the Singapore Convention, is likely to prompt practical developments in our legal landscape that will, I believe, enhance the rule of law. May I highlight 4 potential developments? First, and most obviously, it may do so through the development of international commercial mediation centres in those jurisdictions that ratify the Convention. Such centres may be standalone ones. They may form part of already established international commercial courts or arbitral centres in those jurisdictions. An obvious example of the standalone option is the Singapore International Mediation Centre, established just over 10 years ago. An example of the integrated approach is the London Court of International Arbitration, which also provides mediation services. You could make a similar point about the London Chamber of Arbitration and Mediation. The development of such centres, just as with the development of international commercial courts, signals that a state is committed to the rule of law. Secondly, skilled mediators will need to be trained with high standards set and enforced to ensure that mediation can be carried out effectively and in a manner in which the parties can have trust and confidence. Thirdly, courts will need to be in a position to assist international mediation where necessary, just as they do for international arbitration. There will need, therefore, to be ready access to either domestic or international commercial courts, where, as another one of my predecessors, Lord Thomas, put it, concerning arbitration, they can offer maximum support with minimum interference. This will require investment in courts and judiciaries. In this, we see the complementary, mutually reinforcing relationship between litigation and mediation. Courts, ready access to and respect for them and their judgments are needed to provide the framework for giving effect to rights. They are necessary to support arbitration proceedings. They are also necessary to support mediation through providing the legal framework within which its form of facilitated negotiation takes place. Finally, international mediation's promotion ought also to produce benefits for international arbitration. As I mentioned earlier, one of the Convention's purposes is to reduce pressure on the administration of justice system. Its promotion can equally play a positive role in reducing pressure on international arbitration in several ways. Most obviously, through wider promotion and use of hybrid processes such as Med-Arb and Arb-Med-Arb. Such methods could result in disputes settling earlier and more cost effectively than via a normal arbitral process, in just the same way that the promotion of mediation as part of the pre-action and post-issue litigation process now associated is in England. And we can see in this way some of the cost and the delay associated with international arbitration being ameliorated. And this in turn would increase its utility for those disputes that do call for resolution via an arbitral award. So, if all of these benefits are to be secured, what steps need to be taken? Here, again, I think there are lessons to be learned from jurisdictions across the world. The starting point will be to take a considered approach. Historically, this has not always happened. Sir Ernest Ryder noted this when discussing the approach that ought to be taken to digitisation reforms. Far too often in the past, he said, we have approached modernisation as an exercise in ad hocery. If those states that ratify the convention are to take optimum advantage of its opportunities, a wiser approach will need to be taken. Examples of such approaches can be drawn, I believe, from Singapore and India. Let's take Singapore. Singapore has adopted what could be described as a deliberate and holistic approach to the development of its approach to mediation. Deliberate because, as long ago now as 1996, its government established a committee on alternative dispute resolution. The committee made detailed recommendations concerning the establishment of mediation. Those recommendations included recommendations for the establishment of community mediation schemes, as well as Singapore's Mediation Centre and the Singapore International Mediation Institute. Complementing these measures was the support of the judiciary in the establishment within the courts of Singapore's primary dispute resolution centre, the focus of which was also to promote mediation. Its initial group of mediators were in fact specially trained judges. And the creation of Singapore's International Mediation Centre complements its International Arbitration Centre and more recently, its International Commercial Court, hence holistic. Several points can be taken from this. First, as I have said before, could we see the establishment of a London Dispute Resolution Committee to make recommendations on how best we can provide a holistic approach to international mediation, arbitration, and litigation? Such an approach would mirror the considered approach taken in Singapore. Such a body could draw its membership from those engaged in commercial mediation, arbitration, and litigation, international mediators, arbitrators, commercial court judges, the Judicial ADR Committee, the Civil Justice Council, the Civil Mediation Council, as well as users of the three forms of dispute resolution. Would this not make it well placed to make well-considered recommendations about how best London could develop a more fully holistic approach to the three forms of international dispute resolution, one that views the three as forming a coherent ecosystem? Here, consideration might be given to whether and by what means ease of transfer between the three forms might need to be put in place. If the commercial court, for example, is to provide properly effective support for international mediation, and particularly enforcement of mediated settlements, what amendments might be needed to the civil procedure rules? If arbitration and mediation are to work in a complementary fashion through the provision of Med-Arb and Arb-Med-Arb, what processes need to be put in place? What training needs to be given to arbitrators and mediators so that they can carry out both processes to an equally high standard? I know, of course, one is sitting very close to me now. Very many arbitrators and mediators are well versed in both fields, Lord Neuberger being a prime example. If we are to expand our provision of international mediation in the light of the Singapore Convention, we will undoubtedly need, however, to increase the number of such expert arbitrator mediators, as well as those who focus on mediation. This will call for increased training, the maintenance of high standards, particularly high ethical and professional ones. Particularly important as one of the grounds provided by the Convention for a state to decline to enforce a mediated settlement is a serious breach by a mediator of applicable standards, as well as non-disclosure by a mediator of matters that could call into question their independence or impartiality. In that latter regard, we can also look to Singapore and particularly its International Mediation Institute. The institute was established to regulate mediators, securing and maintaining high standards. We can also look to India. India introduced a specific Mediation Act last year, the aim of which is to promote community mediation as well as civil and commercial mediation. It makes provision for the creation of a Mediation Council of India. The Mediation Act obliges it, amongst other things, to lay down the guidelines for the continuous education, certification, and assessment of mediators by the recognized mediation institutes. It also requires the Mediation Council to adhere to specific professional and ethical standards for mediators, as well as for their training and registration. The Act then makes provision for the recognition of independent mediation institutes responsible for the implementation of those guidelines. Might we wish to introduce a formal council with a similar role as a means not just to maintain standards, but to enhance them? A lot of the work carried out is, of course, already carried out here by the Civil Mediation Council, the Family Mediation Council, and organisations like CEDA. Might there be a need, however, to broaden out their work along the lines identified as I have from India and Singapore? Particularly important, perhaps, given the growth in international mediation and in ensuring that England and Wales are best able to operate as a leading international mediation centre. One of the more recent developments in Singapore might also be something we can draw on. 2016 saw the establishment of the Singapore International Dispute Resolution Academy, based at Singapore Management University. Amongst other things, it promotes training in negotiation and dispute resolution. It also carries out empirical research on negotiation, international mediation, and future developments in dispute resolution. Similar work has, of course, also been carried out and is at the heart of Harvard University's program on negotiation. One thing that could be considered to add to our dispute resolution ecosystem would be the establishment, perhaps, of such an institute within one of our universities to ensure that ongoing development of mediation and the other two forms of dispute resolution, as well as others, were subject to detailed theoretical and, importantly, empirical research. Finally, I want to stress the importance of the legal profession to the effective future development of mediation. It is sometimes suggested that lawyers are not an essential feature of the mediation process. There is, however, a significant body of research, particularly in the arena of family dispute, but which demonstrates the importance of and need for lawyers to be integral to the process, to ensure that their clients are fully appraised of the merits of any settlement and able to consider them in the light of that advice. Where international mediation is concerned, I think it highly unlikely that lawyers would not be involved, just as with international litigation or arbitration. Given that different approaches, different understandings of the nature and importance of mediation are likely to be taken by mediating parties from different jurisdictions, it is likely to be particularly important for legal teams to be well versed in cross-cultural issues. Diverse legal teams with a broad range of experience will no doubt be an important feature of the future development of international mediation. And so to conclude, to realise fully the opportunities that the Singapore Convention has to offer. There is, I believe, much that could be done, and if done, much that would benefit the future development of effective dispute resolution, both here and in other jurisdictions. I wanted to close by recalling something that was said in The Water Margin, one of the great works of Chinese literature. The point was made that if enmity is not settled amicably, there is no end of it. Could that idea stand at the heart of the Convention and its promotion of international commercial mediation? More broadly, could it find its expression in the wider idea that the development of coordinated approaches to litigation, arbitration, and mediation could better promote the amicable, peaceful resolution of both domestic and international disputes, whether through adjudication or by consent? At the domestic and international level, steps can be taken to further such coordination. It is likely that the growth in ratification of the Singapore Convention will promote the need for greater coordination, both within states and between them. And no doubt such promotion will be facilitated through the increasing digitisation of all forms of justice, something which, although I've not touched on it, is ever present where the future of justice is concerned. Just as the first quarter of this century has produced significant evolution in dispute resolution, it is, I think, all too likely that its second quarter will see equally significant change. The Convention will undoubtedly play a major part in that. Thank you very much.
I would like to thank the Lady Chief Justice very much for a characteristically informative, engaging and inspiring talk. It was also a talk which, as I see it, was peculiarly well chosen for this institute. Some speakers, such as myself, can never think about what to speak about and always ask for topics from the people inviting me. Others have greater originality, and Lady Baroness Carr is one of them. She made the choice as to what to talk about, and it is a peculiarly appropriate topic. When one thinks about it, it's concerned with the rule of law, it's concerned with dispute resolution, it's concerned with introducing structures, and it's concerned with global questions and things of global reach. And to that extent, it is very apt for this institute. For me, as she rightly reflects, when I became a judge in 1996, mediation was still in nappies in this country. It was hardly known about. I never engaged in a mediation, and I didn't know a man who did, or even a woman who did. By the time I was master of the rolls, I found myself rather blindly encouraging people to mediate without actually knowing that I was encouraging them what to do. And now I've retired, instead of the blind leading the blind, I'm doing a bit of the blind seeing, attempting sight, and I'm engaging in mediation. It's an interesting experience, and like so many excellent inventions, once one discovers it, one wonders why it wasn't really popular before. And I think you have explained really how it came to its own as litigation and arbitration become ever more expensive and ever more lengthy. The requirement for settling cases has never been greater. And as the world becomes increasingly international, one hopes, despite some rather strong headwinds that have developed recently, that will continue, the need for some international arrangements have become ever greater. And the importance for London to maintain its preeminence in the international legal world means that the message from the Lady Chief Justice today should be taken very much to heart. Lady Carr has very kindly agreed to take questions. And therefore, it's now your opportunity to ask questions. Because it's always sticky to begin with, part of my role is to, I think, ask the first question, which is this.
I'm not sure.
Always throw it back to me if you don't like it. Which is, one often hears the complaint about arbitration, that you can't tell always who the good arbitrators are, because it's conducted privately. Arbitration has become a bit more public, awards are more available, people are a little bit more prepared to talk about it. But mediation is even more private in many ways. And what you were talking about in many ways raised to my mind the question of, you can train a mediator, you can put them into sort of acts and false mock mediations. But in terms of mediation reputation, what do you think one could do?
In what? In terms of increasing privacy?
Well, in terms of making sure you have a good body of mediators. Obviously, training is very important.
Training is key. I mean, I think picking up on your first point, there are so many people in this room who have experienced this, but I always think it's interesting to talk these days about privacy and arbitration, because I think it is not necessarily what it once used to be. And I think I sat on a case with Lord Justice Mayles where we had quite a lot to say about, really, was there a need here to anonymise the parties, because frankly everybody in the industry knew exactly what the dispute was about and who was arguing it. So I think there is quite an interesting separate debate to be had about that. I think you're right that I spoke quite a lot about the various organisations and countries that do regulate and monitor performance in mediators. What regulation is there of you when you mediate, David? None.
Absolutely none. The only experience I've had of being regulated is when in a big mediation there are sometimes two mediators and they, as it were, regulate each other.
Yeah.
But that's the nearest you get.
Yeah.
You're quite right. It's a problem that's easy to identify, but not easy to solve.
I suppose in a way, mediation is a referral profession, a bit like the bar. So if you're not any good, you won't get any work. That's a control lever. But as you can see, I think as mediation gains traction, particularly if you're talking about international mediation, where you may not have those long-standing relationships between the lawyers, regulation may play an increasingly important role.
Yes. There's a question at the back. Please wait for the loudspeaker.
Thank you. I know the rules. I'm a BICL native. My name is Rt Hon. I run the Investment Treaty Forum here. Many thanks for this presentation. And my question is about the expectation from arbitrators. A few years ago, we wrote an article about enforcing consent awards using the New York Convention, because it leads to various legal issues. And one of them is how to prevent consent awards covering some fraudulent transactions and then going to other jurisdictions and enforcing them. And one thing I remember we wrote was that there was a distinction between common law approaches and civil law approaches to mediation. In common law, you see judges sort of taking the back seat, observing and not interfering much in the dispute itself. So essentially the parties run the dispute. While so there was a concern that if an arbitrator would promote mediation too much, it would be seen as interference with the process. So rather than letting the parties do what they're supposed to do. On the other hand, in civil law jurisdictions, for example, in Germany and in Italy, I think already then there was an expectation that judges, not arbitrators, but judges actually actively encourage mediation. And there was even mandatory mediation already years ago. And I think we wrote this article before the adoption of the Singapore Convention. So I was wondering whether you have any thoughts about how far arbitrators or judges can go in proposing that the parties arbitrate, the parties mediate rather than arbitrate, and whether it will not be seen as some sort of impermissible interference of adjudicators, be they judges or arbitrators, into the process.
Shall I do the judging and you do the arbitrating? Here we are, cohesive, holistic approach. So far as this tension was exactly at the heart of the decision we gave in Churchill. You know, the tension between the right to a fair trial, the right to a hearing, and on the other hand, whether or not the court had power to mandate mediation. It's a fine balance. There are lots of arguments. You know, you can't lead a horse to drink if it's not, you know, it doesn't want to participate in mediation. Is there any point in mediation where both parties don't want it, or only one party does and the other doesn't? I mean, I think it's down to good judging at the end of the day. You don't want to look as if you are forcing parties to mediate if they really don't want to, unless there's a very, very good reason. But active encouragement, sometimes for those of you who do mediate, the most intractable problems are capable of consensual resolution at the end of the day. So I think it is part of good judging. You're absolutely right. One doesn't want to appear not to be ready to deliver an adjudication if that is the right solution. But there are very, very few cases where there really is no point in mediation, in my experience. So it's a question of timing, getting the right feel for the dynamics. That will be my take. Barbara, you're nodding.
David, there is a question from David Edwards.
Thank you very much. I was told to look behind me and I forgot. David, please, thank you for being here.
Yeah, that was a fascinating lecture. Thank you very much indeed. I have two questions. The first one is that one of your predecessors, Lord Thomas, expressed concern some years ago about the need for cases to create case law, keep the law alive. And I think you might put it, the deleterious effect on the development of case law of arbitration. And that concern has been expressed by others, I think. The other is that is the question of lawyers acting as arbitrators or mediators some of the time and as counsel for or representatives of parties in other contexts. Now, in the dispute, there's a long-lasting dispute in the European Court of Justice about the enforcement of arbitral awards in investment disputes. And one of the arguments advanced by the European Commission in favor of an investment dispute court is that there is a constant conflict of interest between those who act both as arbitrators and as counsel for parties in arbitrations. Do you have any view about that?
Yeah, I love both those two questions, David. Can I leave them?
Sorry.
No, but I mean, on the first point, I think I mentioned this a couple of points. Absolutely, mediation needs litigation. We need the case law to inform what the proper outcome is of any legal dispute there is. So absolutely, this is the whole point about complementarianism and working together. They need each other. On the second one, I mean, controversially perhaps, but the case that I remember the name now, the Secretariat case, the case that I sat on with Lord Justice Males, and the small world that sometimes exists in arbitration. I think the question of conflicts of interest is a really live and present threat and danger to arbitration, both domestically and internationally, because I think people go quite close to the wire sometimes. I'm obviously not going to talk about individual examples or stories, but I think it may only be a question of time before the wheels come off in certain situations, because it can be quite a small world, can't it? So I think conflicts is an area to keep a very close eye on in the arbitral world. But David, Nick.
I was going to say that I think that the issue about arbitration stealing all the interesting points so that the law doesn't develop in court There are 2 points that occur to me. One is that it's yet another point in relation to a point that you mentioned a short time ago in relation to the privacy of arbitration. Do arbitration decisions really need to be private? I was always brought up to think that the most important attraction of arbitration was that it was private. But talking to more and more people, including general counsel of large corporations, the attraction of arbitration is not so much privacy as something else you referred to, the New York Convention, enforcement. And I think that given that there are some pretty eminent ex-judges and other eminent people who decide arbitrations, that is a bit of an answer to the point. But I do think that the real answer is to consider whether on serious points of law, it is easier to appeal to get a court decision. Secondly, I'd say that mediation is not a problem in this connection, because mediation is to do with settling cases, not deciding cases. And it's not as if all interesting cases are going to be mediated. I see Roy Good has a question.
Thank you very much. I think in response to an earlier question, somebody once said, look, why should parties to a dispute who have bargained for privacy and for finality be used as cannon fodder for the enrichment of English jurisprudence? At some point there. But the other thing I wanted to ask you is finding out how effective these processes are. Years ago, I recall there was an idea of researching into English arbitration practice, which actually we didn't know very much about. And the problem we found was confidentiality. We couldn't actually get our hands on the material. It may be easier now, but it wasn't then, and the whole project just didn't go ahead. So I wonder if you could, it perhaps emphasizes the point that's already been made. Maybe we attach too much importance to confidentiality.
Well, it seems to me that the interesting thing about the Arbitration Act, unless I'm out of date, which is more than possible, is that you can't agree in advance that there's going to be a right of appeal. And that seems to me to cut across the point you make, Roy, that the people have agreed on a certain basis. And I think saying forced to go to court when they agreed not to is the view of the winner, but the loser may have rather a different view.
Well, I'd like to ask a question. You have ruled that a court can direct that there should be mediation. It seems to me they're quite often a situation where the lawyers are not too keen on the mediation, and the lay clients are unaware, really, of the possibility.
Yeah.
And how do you get around that, Mr. Judge?
Well, I mean, we have all sorts of situations where you wonder whether the actual message is getting through to clients. In the old days, one of my predecessors used to call the solicitors, call the parties into court. That's one rather graphic way. I suspect, I don't know, Nick, in immediate thoughts would be, to direct that the parties are, they're undertaking to make sure they're told. I don't know. Duncan may have a view. Duncan?
Well, in arbitration, it's, sorry, Duncan Matthews. It's very common for the early procedural stages for the arbitrators to require the attendance of the party rather than just the lawyers for that very purpose.
And
maybe
remotely.
For the courts to do the same.
Yeah, sorry, straight out to Duncan.
May I? On that point, I used to practice in Canada many years ago when I was in private practice. In Ontario, actually, it was a requirement at the time. I don't know if they've changed it now. I've been out of Canada for a long time, but it was a required part of the litigation process that it must go through mediation en route to a hearing. And I do recall at least one of my cases being resolved at that stage. So it was a required process.
I think the small claims, fast claims, all of that is coming in automatic mediation, but I don't think we're talking about those claims here. But yes, I understand that. Yeah.
Nigel, you had a question. Sorry.
That is still the case in Ontario, and it's in the case in lots of other jurisdictions. And of course, we have started to incorporate that. And just to add, in relation to the Churchill decision, in order to complement that, the CPR has been changed so that the overriding objective includes an obligation, if you put it that way, that the judge shall consider and encourage mediation where it's appropriate. So it's writ large.
Thank you. Nigel, then Barbara, then back.
Nigel Fleming, what the central theme of your excellent speech was the importance of the Singapore Convention, which has not been ratified by the UK. Is anybody in the room, including yourself, able to explain the delay?
I'm so glad you asked me that, because I was hoping there'd be somebody in the room who could give me information. But you know, the previous administration expressed its commitment to ratify.
And nothing happened.
Nothing, well, yes. And now, well, we wait to see what the new administration has to say. I would of course say that I would have thought ratification lay fairly and squarely in any mission for economic growth. But I can't speak about those sorts of things.
I think we're running slightly out of time, but there are 3 questions, I think. So, yes, please.
Thank you. Andrew Cannon from Herbert Smith Freehills.
Hi, Andrew.
My question was very similar in fact, but slightly larger in the sense you mentioned the New York Convention and of course the great success over many years in terms of ratifications by numerous states, I think up to 170, maybe more. We've seen less success with attempts to create conventions for mutual recognition enforcement of court judgments. The Hague Conventions are all stuck in quite low numbers as well and have not taken off in the same way. So outside of regional arrangements like Brussels regulation and so on, that's quite rare. What is it about mediation that we hope means it could follow the New York Convention path rather than the court judgments path?
Oh, that's a hell of a question. What do you think?
Presumably, the truth is that lots of people, lots of countries don't trust each other's judges or courts or court systems because they don't trust each other's governments. And the advantage of mediation is that it isn't governmental, like arbitration is outside. So to that extent, I suppose you could be optimistic. But that's just a off the top of my head guess.
And one thing I'd be interested in is looking at the empirical research side is how many, I mean, given that mediation settlements are by definition mutually consensual, how many failures to meet them are there? How great is the need to enforce? In a way, obviously judgment, nobody wants a judgment against them, they don't ask for them, they didn't want one. But you enter into a mediation agreement because you both want to. What is the scale of non-compliance? Do you know, Andrew? I mean, do you have any direct experience of this?
No.
It may not be a problem.
Yeah.
It is interesting that with arbitrations, prepared to trust an arbitral process, regardless of where it's seated, rather than seated in the state.
Yeah.
It's true.
Which is subject to the supervision of the court.
Yeah.
So, Barbara, you had a question.
A short question of detail to the whole panel, actually. And it's this. ArpMed was widely mentioned, and we have a very great deal of it, particularly in Asia. What is the view as to whether the arbitrator should be the same person who then becomes the mediator and vice versa?
So I'm going to defer to David on that. He really is the person to answer it.
I've done one, and the rule was that you'd have the mediation, and it would last a couple of weeks. And this was the agreement they had. And if they couldn't settle, I would give a non-binding award, which seemed to be the complete worst of all possible. So in due course, the parties got nowhere settling. I thought they'd both got the wrong end of the stick and gave an award, which they both repudiated. And the whole thing was a complete waste of time. So judging something by one experience isn't quite fair, but simply on the basis of that, I'm not keen, at least on the same person doing it. More seriously, the problem is, if both parties know that you're going to have to decide it as an arbitrator. They're not going to be completely open with you as a mediator.
Yeah.
So I think it's a bad idea.
And I suspect it's probably also one size doesn't fit all.
Absolutely.
So you're going to
Thank
have different formulae for different cases.
We've got two more questions, which I'm going to allow, because people have been very good about waiting, and then we'll have to stop, I'm afraid.
Very shortly, Jeremy Carver. Lady Carr, you mentioned very briefly community mediation. I happen to believe that community mediation can operate on any scale, and in particular with the larger, more complex cases with multiple parties, multiple issues, where you need basically to reduce them to something that people can see and feel and take decisions on. Would you like to say more about community?
No, I agree. I was interested. I sort of, as you say, I dipped my toe in that water very gently, and I was wondering whether anybody would nibble, and you have. So I think that's very interesting. I agree. I think it's a very interesting area that we haven't fully explored over here.
Last question.
Well, it's more an observation, if I may, to go back to why the Singapore Mediation Convention hasn't got more parties.
I think it's partly due to the fact that it's not the sort of treaty that is going to be in the top of the in tray of the incoming Secretary of State in America or Foreign Secretary here. But perhaps more importantly still, the arguments against doing something always tend to be voiced rather more enthusiastically than the arguments in favour. I think that what it needs is the CBI to go round and tell Rachel Reeves that this is a vital way of encouraging growth. And if they do that, it will suddenly percolate its way higher up the intro.
Well, there are lots of very important people in this room.
And it means the Lady Chief Justice too.
Lady Chief Justice as well, but I think the CBI at the moment is perhaps an even bigger card,
if I can put it that way.
Right, well, on that note, thank you so much for your questions and joining in, and both in here and remotely. As a result, I'm afraid we've overrun, but that's a good sign, not a bad. I'm sure you'd like to express your appreciation to the Lady Chief Justice.